Yes, Mr. Turner. So I think you'd made 2 of your 3 points.
Yes. Unwelcome precedent setting the bar too low. The procedural issue in the sense that the appellant's notice didn't alert the court to the academic nature of the appeal. And the third point is that it would be unjust to the respondents to count against them the fact that permission has been granted, the money has been spent and court time has been used. And the reason for that, of course, is that the respondent has very limited opportunity at the permission stage to make its point in respect of an academic appeal. Once permission's granted, the appeal procedure is then in train and costs are incurred, steps are taken. And if the point is then decided against the respondent at the appeal hearing on the basis, well, now it's a fait accompli, the money's been spent and we're all here, we've got the court day set aside, so we are going to hear this and not going to dismiss it on the basis that it's an academic appeal. And if you look at that process, the respondent has been deprived of the opportunity to make full argument in relation to whether or not this was an academic appeal or is an academic appeal, save in circumstances where those arguments are heavily weighted against the respondent because of a decision taken that the respondent had no opportunity to challenge.
What's the difference now between deciding the substantive appeal or deciding it's academic?
Well, the difference is that if the court does decide this appeal, the court effectively sets the bar very low for...
No. What's the difference practically in terms of outcome? What difference now does it make to the respondent whether the appeal is decided substantively or not?
Costs,
well,
primarily.
Fine, but the costs would be the same.
Not if the appellants are going to seek an order, should they succeed, that costs follow the event.
Right, but that's all, we haven't got that far. So the only difference, effectively, the answer to my question is potentially costs.
In terms of this appeal, the issue is potentially costs, but in terms of the wider implications of allowing an academic appeal to proceed in these circumstances, where the court
that's the
wasn't
precedent
alerted.
point. You don't need to worry yourself about that.
Yes.
We'll deal with that. I'm trying to be pragmatic and I'm looking for the difference. And the difference is potentially costs.
Cost risk, yes.
Yeah.
So, my lord, those are my 3 points.
Okay.
In relation to
so those are your submissions on the academic appeal. You made your submissions on the respondent's notice. So I'll get Mr. O'Dwyer to see if there's any reply on the jurisdiction and then respond on the respondent's notice, and then you have the last word only on the respondent's notice points, by which I'm including the academic appeal.
Yes.
Yes, Mr. O'Dwyer. On jurisdiction, any reply?
My lord, no, I don't think so on jurisdiction, thank you.
Okay, on the respondent's notice, what do you say about those? I mean, they're effectively the timing points and the privilege points and the nuclear option, those points.
Yes, I had 3 points, my lord. The first related to the point that the end of the stay was approaching, and the second was that...
Sorry, the first point was what?
The point about the end of the stay approaching. So the application was made,
Oh, yeah,
only
yeah.
3 months of the currency of the stay before the claimant would have to do something in respect of that. The second was the 21-day point, and the third was the draconian nature of the unless order with the 3 that I've noted down. Briefly, in response, the The difficulty with the end of the stay point, from my experience, is that it faces the same question. So when it reaches the end of the stay, the district judge and the deputy district judges that consider these present the question to me as the defendant's advocate. Well, I either extend the stay or I transfer it to Part 7. So had we reached the end of the stay, very much like an application I dealt with last week at the end of a stay, that is the options that are provided. And the defendant remains at a distinct disadvantage because the claimant holds the evidence. And if the evidence hasn't been disclosed either before the court or to the defendant, then they're somewhat in the dark about being able to make submissions as to whether or not the claim remains suitable for the protocol, whether or not it should be further stayed.
But that might be said to be a deficiency in the protocol.
It could
because it's not, there's not crisp timings attached to at least some of it.
No, but the fundamental submission remains that it doesn't solve the problem by saying that within 3 months the claimant will have to do something, because the ordinary experience is simply there will be an application made to extend the time for the claimant to continue to comply with the protocol, and the ultimatum usually and ordinarily given by the court is, well, either I extend the stay, Mr. O'Dwyer, or my alternative is to transfer to Part 7. Which do you want us to do?
So then they don't see it as being an alternative to refuse the stay and not to transfer it to Part 7?
To refuse the stay?
Well, I mean, the third option is we're not going to allow the stay and we're not going to transfer it to keep the claim alive.
And that then results in the situation that existed in Cable at first instance and on the appeal before Judge Wood.
Yes.
And then, of course, the approach of the court in that case was to then put the claim out of its misery by striking it out, which was found by this court then to be the incorrect approach and too draconian a measure.
Yeah.
But that was on the facts, though, of that appeal.
Yes. I mean, I don't understand Cable being authority for the proposition that strikeout is never appropriate in any case, but it would have to be, the conduct would have to warrant it.
But the point is that then you say, well, there must be something falling short of that draconian approach, which would give a final opportunity to comply, rather than having to extend it for another 6 months or 12 months or whatever it may be.
That is in effect what our application seeks. It is a last chance saloon.
Yeah.
And the second point, the 21 days, well, that just comes into the discretion that we've gone over. The court would have discretion as to whether it's 21 days, whether it's a month, 2 months, 3 months. And as to the draconian point, by this point, and on this application, the court would already have had to have considered the conduct of the claimant in the progression of the claim, and will have reached a view as to whether or not there is good explanation or otherwise for the apparent delay and lack of progress. So when it's considered that, it will go on to then attach the appropriate sanction. And if it's found that there has been poor conduct in terms of progression, then it is a proportionate sanction to attach an unless order to it. Because, of course, the flip side of this application is the claimant comes to court with very good evidence and the district judge says, actually, I'm satisfied that there is very good explanation. I'm not even going to grant your application for a stage 2 pack. I'm reassured by what the claimant has brought to court that, in fact, it would be premature and inappropriate to exercise that discretion in this particular case. I'll say one final thing about it is that there was some concern about the first instance court being flooded with these sorts of applications, but the reality is this application is a symptom.
Is what, sorry?
Is a symptom. It is cause and effect, and the cause has been that there has become a culture and an expectation that stays will be granted and stays will be renewed without much scrutiny. So if the court is with the appellants on this, that will change that culture, because there will be a message that stays are to be used for the purpose for which they've been granted, to further and comply with the protocol. And there will be scrutiny. And there will come a point where the court will say enough is enough. So I don't envisage in my submission that this would be an opening of the floodgates for hundreds of applications before district judges. Rather, it would be a refocusing of the granting of the criteria for granting of stays and the progress and procedure behind them within the protocol. My Lord, that's what I have to say in response to the respondent's notice.
Yeah.
I'd already dealt with the compelling points, sort of touched on that in my original submissions.
Could I ask, I think consistent with what you've just submitted, you anticipate that applications of the kind that were made in this case by your clients should be fairly rare, should be well judged.
I would certainly concede they should be well judged. Yes.
Well, at the very least, but they're not going to be common, are they?
There are, from my experience, a lot of these cases currently.
Well, that's why I'm asking the question. So what's going through my mind is, what sort of practical steps should a solicitor representing clients in your client's position do before they launch such an application? I mean, I'm just looking at the witness statement that we've got in support of the application that was made here. It starts at about page 188 of the bundle. I mean, did the application, so far as the other side were concerned, did it just come out of the blue? I know you've sent chasers asking for the medical evidence, but was there any warning that an application was going to be made for an unless order?
My Lord, yes, that would be page 190 of the bundle. I think on the 2nd of June 2023, those who instruct me wrote to the claimant solicitors regarding the unreasonable lack of disclosure of medical evidence and information, and putting the claimant solicitor on notice of the intention to make an appropriate application.
Well, whatever that means, an appropriate application. But at the very least, you'd have to warn that. But even before you got to the nuclear option, you would have thought that the parties should be sitting down. How are we going to handle this sensibly in terms of? One would imagine your solicitors would ask, can we not agree a timetable for the remaining stages? Because taking up your submission a moment ago, either you face up to this issue 3 months before the stay comes to an end, or you would say it's going to come around when you get to the stay. But maybe this is part and parcel of the culture that needs to be encouraged. In order to avoid such applications, there is an expectation that the parties will cooperate with each other. That includes claimants and defendants, and they will discuss how to handle the protocol process. Failing which, you then give a warning. We will apply for an unless order.
Yes, well, so
and the nature of the unless order could be tailored to the discussion which had taken place about the steps which remain to be carried out. In this instance, you just focused on a settlement package. That's one step. I suppose it was the next step, and then you put 21 days on it. But it would be better, wouldn't it, if the step plus the period that might be required emerged from some discussion, if that was necessary.
Certainly, my Lord. I mean, this strategy has been developed because of the problem of the lack of response and
But for example, did your clients know, first of all, there had been an expert report obtained and it was available in draft?
No, so we didn't know that. So what's envisaged, certainly in my experience of...
Nor did you know that X-rays were necessary.
So the ordinary course, and certainly what I would suggest is the recommended course, is that there is correspondence sent from the insurer, from the defendant solicitors in the first instance, asking a series of questions. Those questions are usually regarding the suitability of the protocol, given the length of time that's passed, whether or not medical evidence has been obtained, and if so, in what disciplines, an indication of what the heads of loss may be in respect of special damages, whether or not there will be any more medical reports, and a guide as to when they think we'll get
towards a settlement package.
And what then happens, or in a case to which this application process would apply, is that either there is no response to that, and I say that's the culture that's born out of the fact that there's no pressure because the stay can be continued on the claimant's side to have to respond. After a number of months of that, weeks and months of seeking that information, this application is then necessitated after that. I certainly wouldn't be endorsing or recommending an approach that in any case where the claim is stayed, these applications are deployed. They should be only deployed in appropriate cases where there has been no explanation or no adequate explanation, or where there is evidence that has been disclosed that either the case is quite clearly ready for stage 2, so there have been cases where the final medical evidence has been disclosed but not part of stage 2, and there's no reason why any more medical reports would be required. So the expert is saying, this is my prognosis. But for some reason, they're still not going to stage 2, even though they have everything they need to get to stage 2. But also if medical evidence or otherwise has been disclosed, which would suggest the value of the claim exceeds the upper limit.
But where there's only 3 months to go, wouldn't it, given that you've got to go through this sort of dialogue anyway, wouldn't it be better ordinarily to leave it to the renewal of the stay stage? Otherwise, so as to partly avoid proliferation of court hearings, which is not good for anyone.
Well, that sort of builds in a minimum of a 12-month period that the court process would be accepting.
But say for example, I mean, typically, how long does this sort of thing take? About in a 12-month period, about 6 months or so?
Of the chasing correspondence?
Well, no, to actually get a package together, if there's a will to do it.
Well, all of that would be dependent on whether the claimant at any particular moment is in possession of the relevant documents under paragraph 7.32 you were taken to. So have they got a finalised medical report, for example? Have they collated the evidence in respect of special damages, which they're
a lot of that may be dependent on the availability of the doctor, because of course they've got other patients to look at, and that's outside the hands and the control of the claimant solicitors quite often, because you can chase a doctor, but you can't necessarily make him sign off on a medical report until he's good and ready.
I suppose one way of approaching this might be because I'm really asking myself the question: in what circumstances should almost a preemptive strike be appropriate before you get to the renewal of the stay at the end of the first year? It might be in a case where the defendant has accumulated the information to demonstrate it doesn't really make it. There's no point in waiting another 3 months. It would have to be that sort of case, though, wouldn't it? There's simply no point in letting the stay run its 12-month course in a situation where nothing had been done towards the beginning of the stay to say, well, already we've experienced 3 years of delay, and you can tell from this chronology that, frankly, the stay shouldn't have been granted for more than 6 months. But where it's been granted for 12 and then nothing is done to truncate it, hasn't there got to be a very good reason to actually launch a preemptive strike, say, 9 months into the 12-month period?
Not necessarily, my lord, because we're coming back to the point then that of the onus being on the claimant at 12 months, but the options that the court is providing to the parties when the applicant... I mean, a lot of these applications are made simply by ex parte, so the claimant will make an N244 application, simply say, I need another 12 months to finalise my medical evidence, and the court will grant it. There's not even a hearing. We're coming back to the fundamental problem, which is the progression. So whether it's 6 months into the stay, 9 months into the stay, and there's a 12-month stay in place, the problem remains that having had repeated requests for updates and progression, there still isn't, and the concern remains. I should say, in other court centres, there are different orders. I mean, some courts stay these just simply the claim is stayed.
Until?
Just the claim is stayed. So there is no,
no time.
That's a standard Liverpool order from my experience that puts a 12-month, and other courts will maybe do 6 months, depending on their local practice. But the fundamental point is the purpose and nature of our application is that progression. It's always in a context of a lack of progression, a lack of information, or concern about whether or not the claim remains suitable for
But if thinking about it, if you've got a situation where a general stay has been granted, an application of this kind, which suddenly says you're going to have 21 days or 1 month, 2 months to complete your settlement package, otherwise we're going to apply to strike out, that's changing the tempo of the PAP process quite considerably, isn't it? You'd have to be rather more careful if the court itself had granted a general stay.
Yes, but the court, of course, grants these stays ex parte without any consideration of the underlying merit.
That's as maybe. But I'm looking at it from the perspective of the effect and the perception of the claimant, who hasn't realised up until then that timing is becoming more critical.
Well, I think my Lord Coulson made the point to my learned friend in his submissions that the obligation is on the claimant at all times to further the aims of the protocol, which is the swift resolution of the low-value claims. So I think that obligation exists on the claimant at all times, regardless of whether or not the defendant is actively corresponding with them, telling them that that obligation is upon them. But what I will say is that there has to be something before this application is made in terms of correspondence and warnings and seeking information. It would be inappropriate, I would concede, that you'd simply make this application out of the blue without any, at least in the first instance, through correspondence seeking the information that you require. Because as I said earlier in my submissions, there are 4 beneficial outcomes, one of which was, despite the repeated requests in correspondence going unanswered, once a notice of application falls on the claimant solicitors, and they know that it's going to come before the court, that can be the jolt to wake them to think, right, well, if we do need to provide this information, and one of the outcomes of that might well be that the defendant looks at that and is entirely reassured, and it doesn't actually need, and then that risk then falls on the defendant, because if information is provided and they still push it to a hearing, the district judge can say, well, look, this is a good explanation, it's adequate. The stay can stay for the 12-month period, for example. You've pushed it too far. Well, you know, that's a decision that the defendant has to take once that information is provided. And I come back to the fundamental point that the insurer wants these matters to stay in the protocol and wants them to be resolved in the protocol.
Well, that's the big point, isn't it? That it's not much use to your clients to say, well, it can all go off into Part 7, because that's what you're trying to avoid.
Exactly.
With all of the concomitant extra costs and expenses, and very little consolation to the insurer to say, well, you know, the costs and expenses can then fall on the claimant's shoulders, and the claimant might not be worth the powder and shot.
The only tangible real benefit that the defendant insurer gets by the claim going to Part 7 is more control over the progression of the case,
yes,
because the court is then actively case managing it. Directions can be set. The defendant has more involvement in medical evidence, for example, because in the protocol the claimant controls all of that, but if it went to Part 7, obviously they'd have to satisfy the Part 35 test, and the court would say, well, if you want to go and get a neurologist's report, well, there's a date by which you need to get it by.
Yes.
So that's the only tangible benefit of it going to Part 7. And what this application is trying to do is move it forward in Part 8 within the protocol without having to go down that route. Because when faced with those applications to extend the stay, when the options that are given are, well, we can either say it again for 6 months or 12 months and see where we are, or on the defendant's seeking, it goes to Part 7. It puts the defendant in a very difficult position, because it almost inevitably prevents them of any cost protection, because it's them that's saying it needs to go over.
On the question of communications, you took us to page 190 in the table. The at the top of page 190 is the entry for the admission of liability, which was the 30th of July 2020. As I understand it, that then brings to an end stage 1. And I think I'm right in saying that the next time there was a communication sent by the claimant solicitors was at on the 23rd of September, when they sent District Judge Openshaw's order granting the stay along with the claim form. So that's a period of, I don't know, 2 years, 2 months. The one thing that appeared to come during that period is in July 2022, there was something called a Section 152 notice. Forgive my ignorance, but I'm afraid I don't know what that is.
Yeah, my lord, I don't know. Oh, yes, that would have been sent. That does work. So 152 notice is the notice under the Road Traffic Act 1988 that the claimant has to give to the defendant's insurer before it issues court proceedings to engage that provision. So if there is an unsatisfied judgment as against the individual tortfeasor, the all insurance clause under section 152 bites. So if the judgment remains unsatisfied as against the named individual tortfeasor, then any insurer who has issued a policy of insurance would have to satisfy that judgment if it remained unsatisfied for 7 days. So it's a very standard.
So it has to be served by...
It has to be served... I'd have to look at the timings exactly, but I know it has to be provided before the claim form is issued.
Okay, so that was... that would have been taken as an indication that a claim form, a protective claim form under Part 8 was likely to be
coming.
issued. Yeah.
Nothing more than that. It would have simply, it's a formulaic 1 or 2 sentence letter that just puts the insurer on notice that proceedings are going to be issued. I suspect for the purposes that if, for example, the tortfeasor driver has disappeared, the insurer with a contingent liability can apply to have themselves joined to the proceedings, for example, to be able to take active part, because ultimately they would be the ones picking up the bill at the end.
Okay.
So I think that draws to a conclusion my submissions on the respondent's notice.
Yeah.
So it's just the academic argument left. Once again, we've made full written submissions that I would hope could be taken as read, that start on page 7 of the bundle. But there is one particular submission that I would like to develop orally, just to make sure that it is firmly in the court's mind, not least because much of the discussion with Mullin and Friend has been about potentially the issue of costs. I think that's very premature and actually haven't determined the appeal yet, but I think it would be relevant to that as well. And that's the argument that is developed on page 11 of your core bundle, paragraph 7 onwards.
Sorry, could you give me the reference again?
Page 11 of the core bundle, paragraph 7 onwards. And that comes below the table of chronology, which I don't think is controversial between the parties. One of the criteria in the Pop Dog case that you've been taken to is that save in an exceptional case. Exceptional being unusual, not typical, not something that happens with regularity. And I say this is one of those cases for the reasons that are set out there. What's happened in this case is after the order of District Judge Baldwin, the claimant subsequently removed the matter from the protocol. And that was done on the erroneous basis that the defendant had failed to comply with the timescales for the making of an interim payment. And that issue went before District Judge Jenkinson on the 23rd of February 2024, when the appellant here responded by way of the witness statement, which is also in your bundle at page 161. You don't necessarily need to go to it, setting out that the removal from the protocol had been unreasonable. And that was a finding that District Judge Jenkinson made, and it's recorded on the face of his order, which appears in your bundle at page 207. Again, it's common ground between the parties that once a claim is removed from the protocol, it cannot go back in. All that has happened since it was prematurely and unreasonably removed is that it's been stayed again on, I think, 3 occasions, which would have been capable of being done within the Part 8 procedure. And the defendants agreed to those stays, and the reason that they've agreed is because information was provided. Because, of course, when they've agreed to these stays, they've actually had the medical evidence that justifies them, which was the problem which necessitated the application. Once the information is provided, the insurers looked at it and gone, well, it is reasonable to have another stay. The claim is allocated to the fast track. The value remains below 25,000. It therefore, absent the fact that it's been unreasonably removed, remains within the parameters of the low value protocol process. So what the respondent is attempting to argue, and to frustrate the determination of the substantive merits of this appeal, is that as a result of their established and found by the court unreasonable conduct in breaching the pre-action protocol and removing it, that is the only reason that it could ever be termed as academic. The appeal should be firstly dismissed, or that they should have their costs. Whereas if it had remained in the protocol, this wouldn't even form part of the discussion today. And I say that is an incredibly rare event, that you have the, as found by the court, unreasonable conduct of a party rendering an appeal arguably academic, that either one, that should frustrate the determination of the substantive appeal, and or two, should entitle as of right a party to their cost.
Another way of putting it is to say it's not open to a party to say that the claim has become academic when it's their fault that it has.
Yes.
Because a claim normally becomes academic as a result of a settlement or some extraneous cause. You say, well, it only came out because you took a step which was unreasonable.
If it had remained stayed, it would be capable of stage 2 now.
Yeah.
You could make an order today, or remit it to a district judge. It could have been set down for stage 2 and or stage 3. So unless I can, that was the one point that I wanted to expand upon. You have there's everything else I've said about the exercising of your discretion, but
Thank you very much, David.
I'm just trying to fit your last submission in with the chronology. This is page 4 of your skeleton, 17th of October 2023. That's when written notice was given that the claim did no longer continue, but as you also go back one stage, 15th September, application to transfer the claim from Part 8 to Part 7, effectively leading to removal from the portal. But just before that, there was, on the 5th September, so 10 days before the beginning of your table, your client's appeal against, notice of appeal against Judge Baldwin's decision on the 5th of July. So all this is happening quite shortly after he dismisses your application for an unless order.
Yes, it does all happen quite quickly thereafter. It does.
And your notice of appeal against his decision, 5th September, is just before the end of the 1 year stay.
Yes, so when we lodged the original application for permission...
So what if they hadn't moved the claim from Part 8 to Part 7? Presumably you would have said the stay shouldn't continue. First of all, you put in an application for unless order. You didn't get it.
Yep.
You then appeal against that refusal. The stay would otherwise come to an end in September, yes?
Yes.
So something would have to be done about that. And if they had asked for the stay to continue, would you not have resisted that?
What would have happened is the scenario that I explained at the outset of my submissions this afternoon. So we would have gone to the hearing, and the district judge would have said, we can either stay it for a further 12 months,
or it goes into Part 7.
And we would have been forced to say, well, it will have to remain stayed.
But whether or not it went into Part 7 would depend upon, in part, the merits of continuing the stay. In the teeth of, presumably, opposition from your side.
What I suspect would have happened is that the claimant would have said we need more time, as they did. In fact, well, we know what would have happened because it factually happened in Part 7. They would have said we need more time to get the x-rays, to finalise our medical evidence, and the court would have granted a further stay in Part 8, is what would have happened. Because the factual situation actually is there, it's just happened in Part 7, not Part 8.
That's why you say it's not okay. Yeah. Thank you.
But if it had stayed in Part 8, then we wouldn't even be having this discussion, because it would be currently stayed awaiting it. And of course...
So one way of looking at this is to say the decision to remove it from the portal preempted, amongst other things, a decision whether to continue the stay at the end of the 12 months, which is how otherwise you say this should have been resolved.
Yes, well, once that notice was served to remove it from the protocol, that's it. It's out of the protocol. There still remains the stay.
I'm making a very simple point. In September, if this action hadn't been taken, there would have been a straightforward discussion about whether the stay should be continued and Part 8 carry on.
Yeah.
In which case, the appeal would not be academic.
Precisely.
Well, yeah, okay.
And I think...
At least not academic for the reason advanced.
I have a feeling that the respondents were aware of our appellant's notice by the time they took it out as well. So our appellant's notice before Judge Wood.
Yeah.
And the only other relevance of that point actually goes to the other submissions that are made in writing, which are, if this case wasn't determined and grappled with today, that same scenario would potentially present itself in every other opportunity, because it's taken us almost 2 years to get here. If it wasn't dealt with and grasped today, then simply we'd start the process again, but would be liable at any time to the claimant either removing it from the protocol or submitting the Stage 2 pack. My Lord, if I can assist any further.
Thank you.
No, thank you very much. Yes, Mr. Dwyer. So it's any reply on the respondent's notice points or the academic point?
Yes, my lord. Firstly, in relation to the academic appeal, as that's of course just been dealing with, my learned friend says all that's happened is a further stay. Well, at page 214 of the core bundle, you'll see that the claim's been allocated to the fast track, full directions have been given, and a trial window has been set. So a lot more has happened other than a stay. Next, the question of whether effectively the respondent is attempting to take advantage of its own wrong by arguing that this appeal is academic because the recording of District Judge Jenkinson is that the claim was wrongly removed from the protocol in September of 2023. The difficulty with that for the appellants is that this claim would not have proceeded along to a stage 3 hearing in any event, and that is because of the provisions in relation to interim payment. And they appear at 7.19 of the pre-action protocol, which is at page 326 of the authorities bundle.
326.
Yes.
Yeah.
And at 7.18, 7.19, there are provisions in relation to the ability to apply for interim payments, and you cannot apply under the protocol for interim payments in addition to the interim payments which are prescribed there. So if a further interim payment is required, for example, for medical treatment or investigations, i.e. X-rays or MRI, the claim is removed from the protocol process.
Sorry, which paragraph is that?
At 7.18
Yeah.
provides for the interim payment of £1,000.
Yeah.
7.19
Yeah.
provides for an interim payment of more than £1,000. And this, of course, is all done online under the
But less than the amount
protocol.
requested by the claimant.
Yes, but there's no provision then, once you've utilised that facility under the protocol, to then go back and ask for another interim payment. If one is required, the claim exits and goes to the court.
What bit says that?
I'm taking that on instructions from a solicitor who operates in relation to these claims.
That seems absurd. Surely if things are progressing and there's simply a question of an interim payment, another interim payment, you seek that.
Well, it's 7.28, I think.
7.2.
8 on page 327.
Ah, yes, it's 7.21.
I was wondering, 7.21.
Because this claim is not over £10,000, then you are restricted to one interim payment application. So if you have a case as here, where you have...
So you can fiddle the whole thing by making an interim application. You can get out of the protocol by making a second application.
That would be an abuse.
So much for the integrity of the protocol process.
Well, that would be an abusive process, my lord, and that would be visited upon any party that did that in due course.
Yeah,
There
like
wasn't
the
a
unreasonable
legitimate
exiting of the
request.
portal.
Yes, but that's not the situation we have here. There's no suggestion here that the request for funding for X-rays, MRIs, there was then a further X-ray to see whether the claimant was suitable for MRI.
Had there been a previous, I'm assuming that therefore there had been a previous application for £1,000 and it had been exceeded to, is that right?
Yeah. Yes. Now, if we see
Where's all this
that,
set
Where's
out?
it come
Where-
from? I
where-
mean, this is...
It's absurd that we are now dealing with absolute nuts and bolts
well,
of
my
the
lord, but
process. Where is this set out?
the first interim payment is set out within the document support.
Is it in the skeleton argument? There are separate skeleton arguments about academic appeals. So is this set out there?
Not that I'm aware, but the point is, if it's going to be held against the claimant on the basis that it's abusive, effectively the claimant trying to take advantage of their wrong.
Well, that's always been the defendant's position in relation to academic appeal.
Not in relation to interim payments, that came
Well, no,
later.
not just that it was taking advantage of its own wrong because it wrongly,
Unreasonably came
unreasonably exited the portal.
Yes, it did
I
at that
understood that
stage.
from my pre-reading, that was their
Well,
point.
my lord, the fact is that there were multiple interim payment requests, and that meant because the claim value is below £10,000, the claim would have exited the portal in any event. I don't go into it in any more detail than that.
That makes me think this appeal is not academic, because some procedural rigour may be a jolly good thing.
It's strange, isn't it, that you've got a claim that's valued at... This just doesn't make any sense. These rules don't make any sense. The claim is valued at more than £10,000. You can ask for more than one interim payment. If the claim is valued at less than £10,000, you can only claim one interim payment, even though the claim that's valued at less than £1,000 might actually require you to pay more than £1,000. The claim that's under £10,000 might actually require you to make payments that are almost as much as the claim is worth.
Can I just say, I beg your pardon.
Sorry, no, carry on.
You mentioned the need to make an application for another interim payment. And I think you said in connection with the MRI scan.
Yes.
Well, if I go to page 74 of the bundle, there's a footnote. I'm not an avid reader of footnotes, but there happens to be a footnote 3. The MRI scan was recommended in an addendum for May 2024, and the appellant has agreed to provide a further interim payment to fund the investigation. But that's in 2024, whereas going back to page 11 of the bundle, the claim had been removed from the protocol back in October 2023.
Yes.
So
It was wrongly removed
really,
at that point.
I'm not following this.
The first recommendation and interim payment was in respect of an X-ray. And then when the X-ray was equivocal, there was a request for an interim payment in relation to an MRI. There is actually a chronology.
I'm so sorry, but you were telling us, I'm sorry if I've misunderstood this, you were telling us that this would come out of the protocol anyway because of the need for a second interim payment.
Yes.
But quite apart from my Lord's question as to whether we have information about that, the way you put the point is the second MRI payment, second payment was related to the MRI, that's 2024. This case was out of the portal in 2023.
My Lord, in relation to my Lord's point about is this in the bundle, there's a chronology at page 88, which has the request for the first interim payment as 21st of September 2023.
Shortly before the case came out of the portal. That's the first one.
Yes. And the case came out of the portal because the claimant's solicitors had miscalculated because they had served an inadequate interim settlement pack requesting an interim payment without annexing the medical report. They then served a compliant interim settlement pack, but they calculated their days from the earlier action, so they prematurely took the claim out of the portal.
Right.
But the second interim payment is 21st of November of 2023, page 89 going to page 90, and that can't be done.
Sorry, page 90.
Page 89, bottom entry, 23rd of November 2023, going over the page to page 90.
Yeah, so that's the second interim payment was requested and paid.
It was paid on the 5th of February of 2024.
Fine.
See that there.
But then, I'm sorry to...
So hang on a minute, so it was paid?
Yes, because the claim had left the protocol process by
Yes,
then.
it left in October of the previous year. Also in the same chronology, page 89, 17th of October. So I'm still at a loss to follow the point.
So my learned friend's point in relation to academic appeal is effectively, had it not been for the claimants wrongly extracting the claim from the protocol process in autumn of 2023, it would still be in the protocol process. It would still be heading to a stage 3 hearing now, rather than a part 7 disposal hearing, fast track trial. The point I'm trying to make, and I apologise if I've gone around the houses, but the point I'm trying to make is that's not actually correct. The claim would have had to leave the protocol process
Later on in 2023.
later on in any event. So we would have been here because a second interim payment was required to fund imaging, and you can't apply for that process on that second interim payment in sub £10,000 claims under the protocol, and so you have to extract the claim from the protocol to make that request.
That second interim payment was to pay for x-rays. See the top of page 90.
Yes.
And that was because there was some failure to deal with the medical aspect properly in the first interim package. I think you said a moment ago. It got nothing to do with the MRIs. They're on in 2024. But the second interim payment was for the x-rays. And there was I think the chronology says somewhere, if you go back to page 89, 9th of August, interim settlement pack, submission of medical evidence failed, resubmitted on the 30th of August. So that's the first request. The second request relates to the x-rays, and that's the top of page 90. This is where you need a witness.
We have a moment. Yeah, I've got that. Yeah, it's the interim received on the 5th of February of 2024 is the first interim payment. And then the second interim payment is received on the 17th of May of 2024. And the MRI scan is recommended, you see the entry on the 1st of July of 2024.
The page reference for the chronology, there are so many chronologies. The chronology that you were just referring to.
This is the chronology at page 88, it is tab 1.9.
88. Right, so that if we just assume there were 2 interim payments sought and made, you say the fact that there was a second one meant that it had to exit the portal.
Yes, because it is a claim below £10,000.
Yes, and that rule is which?
7.21. But it's the section...
7.21 is where the claim is valued at more than 10,000. This isn't that.
So the power to apply for one interim payment is implicitly excluded for claims.
Implicitly.
Well, my lord, the understanding of the protocol
this is a cost-free, self-contained, very easy portal that everybody wants to comply with, so it doesn't go to court. And you have to come out of that easy, self-contained portal because of an implicit provision that you can't have you can't ask for a second interim payment?
Well, there is a specific rule that says...
Yeah, which? I've asked you now 3 times.
7.21,
It doesn't. 7.21 is for claims over £10,000. This isn't. So you have to say it's somehow implicit. There's an implied term of this self-contained special portal that means that you can't make an interim payment, can't request a second interim payment, even if the defendant is willing to pay it.
It's very odd, isn't it? Because whilst I can see why you might argue that on the basis that it says specifically if you want more than one if you've got a claim over £10,000 and you want more than one payment, this is the way to go about doing it. And it could be said, well, then it's assumed from that you can't do it for something less. It just doesn't make any sense. Because there's bound to be situations, time and again, where for a claim that's under £10,000, you'd be spending more than £1,000. And the idea that is a sort of knockout blow and it all has to go out seems to me to be really, really odd. I can't see any sense or logic behind it at all.
The only thing I could think of possibly wrongly is that it's putting pressure on the claimant, the claim under 10,000, to have one go and one good go at seeking an interim payment. It's a low value claim, therefore you have one shot at it.
Well, it would put that pressure on, but it does mean that where an expert, as here,
because it's trying to keep the costs down, so you can make one request
rather than replying in dribs and drabs.
Yeah.
But you then have situations.
But then you have to exit the portal, come out of Part 8, go into Part 7, all of those costs.
My lord, 7.21
It makes no sense.
says what 7.21
It's about time we had, perhaps I was wrong this morning, about time we had some district judges weighing in with these implicit labyrinthine rules.
Well, my lord, I've made the point that it says you can only get more than one if you're over 10,000.
Yeah.
And
no, I understand the solution.
the understanding is that that implicitly means if you're less than 10,000, you can't get more than one interim payment.
Yes, but then you say you can't get more than one interim payment, so you exit the portal.
Well, if you need the interim payment to fund the imaging, that is what has to happen.
And go to Part 7.
Well, in this, it's not the MRI. The second payment relating to the X-ray. The MRI came subsequently.
Yes, apologies for any confusion over that. As I understand it,
The X-rays, as I understand it, was something that were required in the report produced in May, the first one, the one which was draft and protected by privilege.
if I could just have a moment, my lord, because I just need to make sure, before I address the court on this, that I've got it absolutely right.
Taking that from the witness statement that was before the district judge.
The riding one.
I think so. But, yes, paragraph 10, page 198. So that witness statement, which is in response to the application which has ended up before District Judge Baldwin, is made on the 28th of June 2023, mentions the X-rays, and where's the chronology? 88, isn't it?
Yeah.
The first application for an interim settlement pack was after this witness statement, on the 9th of August.
Sorry, there was
Which is why the X-rays are mentioned at the top of the next page.
2025.
Page reference.
91.
It's not easy to follow some of
Well, there's a third
missing
interim
from the
payment.
first.
things. It looks like it.
And then,
That's picked up at the top of page 89.
yeah, and then there's an application for second interim payment for the X-rays.
Yeah. Well,
For an academic appeal, you're certainly weighing in on the detail, Mr. Turner.
My lord, I'm trying to avoid it.
Well,
But a point has been made, a very specific factual point,
yeah.
that this would not have exited the protocol process and would still be there having a stage 3 hearing under the practice direction,
Yeah.
but for the error in relation to extracting the claim from the protocol in September of 2023 due to the miscalculation of the interim payment due date. The point simply made in response is it would not, because multiple interim payments, there's actually a third interim payment at 16th of September of 2024, at page 91 of the chronology. Multiple interim payments, I can put it very succinctly.
But the second interim payment was sought because there was a cock-up and it hadn't been claimed in the first.
Well, Lord,
Work
no.
that out from the witness statement and the chronology, because the first didn't include the x-rays. And then the second one, the second interim payment was seeking the x-rays which hadn't been claimed in the first.
Well, Lord, I really wish to avoid delving into facts in that depth. The explanation, as I understand it, is
We've got
X-ray.
we've got the witness statement and we've got the chronology.
X-ray then sent for MRI. MRI requires X-ray to check that candidate is suitable for MRI. That's further X-ray and then MRI. So that's the order. And if that is not ascertainable from the chronology, then I accept there is no material in that form.
well, forgive me, but page 91, 1 July 2024, Mr. Malik, the consultant, that's where he recommends the MRI, see line 2.
Yes.
Which is consistent with the footnote, which I drew attention to.
Anyway, there it is.
Respondent's notice, my lord, very briefly.
Sorry?
Points in response on respondent's notice.
Yeah,
Dealt with
yeah.
Academic appeal. Her ladyship proffered a third option, which is the court could not extend the stay but not transfer to Part 7, which would have the effect of effectively taking the stay away or lifting the stay and leaving the claim in limbo. The practice direction actually deals with that at paragraph 16.6.
Right.
So if the court did not extend the stay, lifted the stay, or effectively lifted it passively by allowing it to expire, refusing to renew, and the claimant would be obliged to take those steps at 5.2 and 6 and file the documents at 6.1. If the claimant didn't do that, now those stages are within the practice direction, that would be taking the matter towards stage 3. If the claimant didn't do that, the claimant would leave the protocol and go to Part 7, and if the claimant had done that unreasonably, then the claimant would face the cost consequences.
Sorry.
face the costs, consequences potentially under what was 45.24, but is now 45.35. And for completeness, page 326, in the pre-action protocol, there is actually a paragraph dealing with stays, which is at 7.12. Which says where the claimant needs to obtain a subsequent medical expert report, the parties should agree to a stay in the protocol. So there is provision in relation to stays within the protocol where further medical expert evidence is required.
A subsequent expert medical evidence, so report. So this is stage 2, and so this is stage 2, and it talks about the medical reports at 7.1, non-medical reports at 7.9, and that's a stay for a subsequent expert's medical report.
Yes, the anticipation is that there will be a single medical report in these cases. If that is required, the protocol is flexible enough to allow the parties to agree stays between them without having to come before the court. That's in relation to the protocol process, of course, not in relation to proceedings. Finally, brief factual issue on the respondent's notice in relation to the question of the defendant effectively teeing up any application by sending correspondence to a claimant saying, we haven't heard anything, if you don't respond, we're going to do this. Tab 1.18, page 198, is the witness statement that was put in opposition to the application. Back in September of 2023. June of 2023. The application was in July. And the court will see from paragraphs 13 to 16 that there were email communication issues here. An address, the defendants had been using an address which wasn't recognised. The bounce back would have given another address, but there were no messages sent to that address. And essentially there's miscommunication between the parties. Just to correct the impression here that we had a claimant who was serially ignoring correspondence which would have been received by the solicitors.
Well, the claimant wasn't doing anything.
Well, the claimant wasn't. This is in relation to the point about, my Lord's point about the defendants would need to send correspondence prior to the application. And in this case, the defendants say that they did, but they sent it to an email address, which meant it wasn't received. So it was effectively cross-communication between the parties.
No, cross-communication involves two parties. Claimant's handler was on long-term sick. The claimant hadn't been informed. Sorry, the claimant hadn't informed the defendant of that. So even if the emails had gone to the right address, it wouldn't have made any difference. It's all defensive, even though this is the claimant with the obligation to progress the claim. That's why I said it's COVID ETMA homework. It just is. It's all untenable stuff.
Well, my Lord.
And if there is, I mean, as this appeal's wound on, I've become concerned that these claims are taking too long. If this is anything like standard, these claims are simply taking too long. The limitation provision is there for a reason. And the conventional wisdom is, if you wait until the end of the limitation period and you then commence proceedings, forget about protocols, you're under an obligation to really get on with it because you've waited till the end. here, because of the stay, actually they've waited beyond the end. So,
My Lord, that comes down to duration of stay, and it's never been contested that there is no prescribed period for a stay under the protocol, and the court can give such stay of whatever duration the court sees fit without hearing any application on the merits or without seeing any information or evidence in support of the application for a stay.
I mean, the provision is designed to help claimants. That's the only reason any of this exists. It's designed to help claimants who are obliged to use the protocol. And the Civil Procedure Rules Committee was concerned that if they were obliged to use the protocol, they might get mired in a process which had the risk of threatening their ability to make a claim by reference to the Limitation Act. So all of these provisions are designed to help a claimant, but they're not designed to allow slow, winding civil litigation by another means. That's the thing. Anyway, you draw our attention to paragraphs 13 to 16 because those are that's the explanation for effectively why you say that there wasn't deliberate ignoring of correspondence.
Yes.
Yeah, I understand.
Perhaps we should also look at 17, because it makes the point that the claim has stayed for another 3 months. It would have been our intention to update solicitors for the defendant to the present position before this time, etc., etc. So in that context, that's why I asked your opponent the question, did they know that a draft report had been obtained? Were they told that? So leave aside the fact that they were sending emails to the wrong address. The claimant responsible for progressing his claim wasn't telling the other side, well, we've now got a draft expert report.
Well, the draft expert report, my Lord, I'm just looking for the date it was received.
It was May, wasn't it?
No, so this statement is 28th of June, so it's only shortly before.
Yeah.
And the application issue date would have been, because this is a statement in response.
Well, forgive me, I'm looking at 21. The appointment with the surgeon was in January 23, first draft 9th of May.
Yes. Yes, and a letter had communications been ongoing between the parties. A letter could have been written saying the appointment has taken place, we are awaiting the expert report. No further points, my Lord, unless there's anything the bench would wish me to address.
That's fine. Thank you very much. Well, for an academic appeal, speaking for myself, I think there's some quite interesting and difficult points. You will therefore be unsurprised to learn, both of you, that we will not be giving you extempore judgments this afternoon. We'll reserve our judgments. When the time comes, you'll get a draft judgment. That's then an opportunity for you to comment on our grammar and our typos and any factual misstatements, but it's obviously not an excuse to re-argue the case. When you get that draft judgment, we hope that you'll then be able to agree the consequential orders. If you can't, then the best thing to do is to provide a copy of an order with the two competing versions on the things you don't agree in different coloured print so that we can see where the differences are. And you can also provide very short 2-3 page submissions in support of the particular points you argue on the order. The draft is confidential, so as you both know, it can't be shared with anybody other than those people on the list that have been provided to my clerk. and until the judgment is handed down, that remains the position. When judgment is handed down, you will not need to attend because it's handed down electronically. If the judgment is all done and dusted, but there's still argument about the final order, the judgment might be handed down and the points on the order resolved a few days thereafter. All right, I don't think there's anything else, so thank you both very much.
Right,